Five, four, three, two, one.
This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon and welcome to the Tennessee Court of Appeals. We appreciate you agreeing to participate in this oral argument via Zoom. I have the, distinction to tell you that probably, unless something changes the way that we have plans so far, this will be the last Zoom argument made in the Court of Appeals. Next month, which begins tomorrow, we'll go back to in-person unless things change. But we appreciate you participating. We think it's the best way to have conducted oral arguments since we've been using it. So thank you again for that. Having said that, though, we will utilize the same rules, procedures, and protocol as if we were all standing in the courtroom together today. We do not expect to experience any technological problems, but if we do, everybody just remain calm. We'll get it worked out, and we'll make sure that nobody's rights will be prejudiced in any way. Before we begin arguments, I want to introduce your panel for this afternoon. We have Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Ms. Kraft, anything we need to take up before you call the first case, or call this case rather?
No, sir.
All right, you may call the case.
Benny Vaughn versus Coffee County, Tennessee.
And we will hear from the appellant.
Good afternoon, Your Honors. I'm Drew Justice for the plaintiff appellant Benny Vaughn. I'm from Rutherford County, and I'll reserve 3 minutes.
All right, sir, you may proceed.
This is a case about slipping in water in a jail cell, a county jail, leading to a hip fracture. What the lower court did in this case that we're claiming error on is that it granted summary judgment to the defendant, Coffee County, basically saying that the plaintiff's testimony could not overcome the credibility of 3 defense witnesses who were jail guards. And then there was a 4th witness that three defense witnesses that they offered affidavits from. Basically, on the issue of whether the plaintiff told those witnesses before the injury about the defect that led to the injury. And so that was basically the issue that the trial court ruled against us on of actual notice. We're also complaining that the trial court failed to consider or even really address whether the jail had a duty to find the defect regardless of whether it was told about it. And that would fall under the category of constructive notice. Now, on actual notice, the reason that the trial court erred on this credibility issue is that the trial court was required to accredit the testimony of the plaintiff since it was at the summary judgment stage. And really the law on that is very clear. I don't think the point even really needs to be belabored. Now, what the county has responded
Let me ask you a question, Mr. Justice. What did the trial court say about your client's testimony?
What it specifically said was, says the plaintiff's uncorroborated deposition testimony does not overcome the sworn statements of these 3 jail employees. And that's from record page 128.
And what was the specific issue that your client testified about?
My client testified that he told those 3 individuals and also a 4th individual who we don't have any affidavit to the contrary from about this defect.
About water on the floor?
Correct. And he testified.
I'm sorry, but just tell me generally, but as specifically as you can, what he testified to, please.
He was asked who he told the defect to, and he listed those 4 names. One of them was the jail administrator, 2 of them were 2 regular guards, and then the 4th one he didn't list a name for, but he said it was just the maintenance man.
Okay. What did he tell them?
That the toilet was leaking and causing water to be on the floor, and that was a problem. And then one of them, he specifically testified that he told him that he had already slipped on it once. That was, he said, a few days prior to the hip injury, he talked to Officer Flores and told him that about the water and that it had caused him to slip. So basically he slipped twice. The first time though, it didn't really seem to damage him. But so, you know, I just submitted, it's, you know, if he testifies that he told these 4 different people, they can deny it. And then, you know, you can have a trial over that, but you can't just accredit their denial on summary judgment. Now, the Coffee County's response is they've said, well, Mr. Vaughn didn't specify exactly when he told these different employees. I submit it's clear from the deposition testimony that he told them about it certainly before the injury. And that's certainly the way defense counsel interpreted it during his questioning. On page 273 of the transcript, it's record page 18. Defense counsel, you know, in response to Mr. Vaughn's testimony, defense counsel said, okay, so the whole month before you fell, nobody came and looked at it. So it's clear from the context that he, you know, was complaining about it to these 4 individuals before the injury. And as I said, he explicitly says he told Officer Flores a few days prior to the injury. So, you know, regardless of whether he, you know, listed an exact date of when he told them, I mean, he made it clear that he put them on actual notice of this. Aside from actual notice, though, we've also raised constructive notice, which really has, you know, doesn't even require any credibility from the plaintiff, or not. It doesn't primarily rely on that, at least. The reason the trial court erred on the issue of constructive notice, aside from the fact that the trial court didn't even address constructive notice, is that you know, if the jail had a duty to inspect and clean the cells, and if these cells were flooded pretty much continuously for a month or more, then they had constructive notice. Constructive notice means imputed knowledge that the defendant could have discovered, and that his situation cast upon him a duty of inquiring into that, you know, defect. That's from Kirby versus Macon County. And then in Blair versus Westtown Mall, the Tennessee Supreme Court also talked about this idea of a recurring incident or general or continuing condition. And I submit, if you've got flooding that goes on more or less continuously for a month or more, then that's a recurring incident or general or continuing condition. So if you've got that recurring or continuing condition, and you've got a statutory duty to inspect and clean the cells every 24 hours under TCA 41-4-111, then it just seems pretty cut and dry that you do in fact have a constructive duty to find this defect, even if Mr. Vaughn never complained about it. Coffee County on the constructive notice topic has said that the plaintiff hasn't shown that this statute 41-4-111 confers any private right of action. We're not arguing that the statute confers a private right of action. What we're arguing is that that statute confers a duty on the jail to find the defect, which would create constructive notice. And so ultimately, you know, again, if the jail is on constructive notice of this defect, the reason why that's at least somewhat important is because then you don't even have to believe the plaintiff that he told these 4 people. Sort of makes the credibility determination largely irrelevant. Now, on these other issues that the defendants have raised, the defendant has said that they haven't really even faulted the trial court as being in error, but they've just said, well, the trial court never got to these other issues, but let's turn this court into a trial court and y'all should grant me summary judgment on those issues instead. And our main position on that is that that's just not a proper use of this court's appellate jurisdiction. And I've cited 1 or 2, I think 2 cases to that effect where this court has basically said as much. It's just really, we don't believe it's proper for the way our system is set up is you're supposed to have some judge who intelligently considers an issue and then does his or her best to decide it. And then if someone is aggrieved by that decision, then they appeal to this higher court, which has three other intelligent people looking at that original decision, going through it line by line and trying to decide, well, this decision was basically right, or we think this decision was wrong. If you just sort of cut out that first level and try to turn the panel into the first judge, I just submit that really short circuits the process. It gives us only 3 heads instead of 4, and just 1 tier instead of 2. And so I submit that that's the wrong way to go about things. And so what I'm asking is that on these issues that the court did not address, that those issues should be remanded to the trial court to address in the first instance. However, we did, if this court were to decide otherwise and were to go ahead and just address the other issues, this issue about whether the jail had a duty that it fulfilled to the plaintiff, that was an argument that the defendant never even raised in the trial court. So I submit that that's waived. On this issue of whether Mr. Vaughn was, as a matter of law, comparatively negligent, basically our response to that is that Coffee County is misstating the record to say that Mr. Vaughn was running through the water. In reality, there's no testimony that he was running through the water. The closest that he comes to that is he just says he was in a hurry to get his food, and therefore he admits that he didn't climb over furniture to get around the water. He says he just walked through the water. So on this issue of him running or going fast, that's a misstatement of the record. And then on this admission that he makes that he could have avoided the water, we submit that does not make him comparatively negligent as a matter of law, that a reasonable fact finder could find otherwise, for a couple of reasons. One is that he's an old, mentally ill man, and he's got to eat, and it just makes sense that the jail would be put on notice that he's going to, in most instances, want to take the most direct path out of his cell and not have to climb over furniture to do it. Secondly, just the fact that he's testified that this whole defective condition went on for over a month, and that Coffee County never during any of that time did anything about it, that makes them grossly negligent, not simply a little bit negligent.
Let me ask you, Mr. Justice, do you dispute apparently the finding by the trial court that the only flooding that the jail was aware of was flooding that occurred 2 days before your client's fall? And that flooding was caused by him stuffing his clothing into the commode. And then that was cleaned up. And at that time, apparently, they didn't find any leaks from the commode itself.
We do dispute that was the only time that they were put on notice of flooding in general. We also dispute that he intentionally flooded, caused the toilet to flood. We don't dispute that the toilet did indeed flood some on that day, and that was cleaned up. I believe the records seem to indicate it was cleaned up over a day after the fact, but so we're not disputing that happened, but we're disputing that toilet incident was very relevant to the situation. That was above and beyond the normal leakage. That was a situation where just the toilet got stopped up and flooded some. And we are disputing that was the only flooding that they were ever put on notice of. And so with that said, I guess I'll reserve the rest of my time for rebuttal and ask for a reversal of the judgment.
Thank you. We will hear from the appellee.
Good morning, Your Honors. Gina Vogel here for the defendant appellee, Coffee County. I kind of like to start off where Judge Armstrong kind of inquired as to this flooding incident that occurred right before or within a day or two of the incident we're here about. Why that is completely material to this case and why it supports the trial court's finding is that even if you want to credit, and even if we need to credit plaintiff's testimony that he told the defendant at some point prior within this month that there was water in his cell, as of that day, there was not water in his cell anymore. So even if they had actual notice up until that point of a condition that they did not remedy, it was remedied and it was clear at that point. So as of December 18, 2017, there's no dangerous condition that they are aware of in his cell. The reason why the toilet flooded or the whole pod flooded is irrelevant. And the reason why the water ended up being remediated really isn't irrelevant either. What's relevant is that at that time, the actual notice that's been alleged in this case ceased to exist. And from that point to the point of his fall, there's no proof of actual notice of, again, the dangerous condition being water. There's no proof of actual notice in this case. The plaintiff did not report it again. There's no proof that the defendant, any defendant officer walked past the cell or walked in the cell and saw water on the floor. There's no proof as to when the so-called water reappeared. Plaintiff didn't say, well, 5 minutes after they mopped it up on this day, it came back, And so there is no proof of actual notice in this case. If we look at, essentially what happened leading up to that December 18, 2017 incident and cleanup is just a red herring. We have to look at whether Coffee County had actual knowledge of the dangerous condition, and the dangerous condition is water. Did they have notice of it leading up to that point? And the answer to that, based off the undisputed material facts in this case, is just that they didn't. And that can carry, and it kind of carries over into the constructive notice argument as well, because plaintiff wants to say, well, even if you didn't have actual notice, did you have constructive notice? And plaintiff relies on statute 41-4-111, but has no proof that the county was in violation of that statute, particularly at this material time from, after it was cleaned up until he fell. There's no proof that inspection did not occur, but he makes an even bigger leap to say, well, had you done the inspection, then you would have realized what was wrong and so forth. Well, there's no proof of that. There's no proof that the water existed at that time, so that you can't just make the inference that, had they done an inspection within 24 hours, that water would have even been there. The plaintiff himself testified that this was a very slow occurring thing. And, which kind of leads into plaintiff's additional arguments as to constructive notice that this was a recurring situation. But plaintiff's own proof is that it wasn't recurring. It was a consistent state. He says that there was the same wet spot in his cell from the time he got in there until the time he fell. He said it was a continuous wet area. And so this isn't like Blair versus Westtown Mall, where you have a recurring instance, meaning something happens, maybe it's addressed, maybe it's remediated, maybe it goes away on its own, and then it comes back. Plaintiff isn't saying, oh, my toilet was leaking and then someone was cleaning it, but yet it would come back, or I would mop it up and then it would come back. This is the existence of water at all times, just sitting there. And so that's why the recurring instance doesn't support plaintiff's position in this case as to constructive notice. And so I think while the trial court considered the deposition or considered the declarations of the defendant witnesses in this case, was because, as far as I can tell, the part of the deposition testimony that plaintiff now relies to give context as to whether or as to when plaintiff complained to jail administrator Freeman, which can kind of get him into that reporting the incident before reporting the water before the incident. That portion of testimony was not highlighted by the plaintiff to the trial court. It wasn't used to dispute any fact that we designated as undisputed, and plaintiff did not submit any additional material facts citing that particular portion of testimony, saying, no, there was in fact actual notice if you look at the entirety of this testimony. And so to me, that's why the trial court did in fact give credence to the proof of the defendants, because otherwise it was undisputed at that time. But even if your honors want to consider now that there has been some context as to that testimony, yes, maybe in fact, did the plaintiff complain of water in his cell at some point in that month? All that is really immaterial because of the unrelated flooding incident that occurred on December 18. And so, again, the actual notice has to go to the dangerous condition. When did they know water was in plaintiff's cell? They might have known it up till December 18th, but they didn't. There's no proof that they knew of it after until he did, in fact, fall on the.
Let me ask you about this December 18th incident.
Okay.
What was the problem that caused the flooding on December 18th?
Well, it's defendant's position that it was plaintiff who caused the flooding by putting clothes in his toilet. But even if, that's apparently what the defendant's inspection or look into as to the cause was, but I don't really think the cause of what happened is material.
Okay, bear with me here.
Okay.
Was there a determination about why the toilet overflowed on December 18th?
I think the undisputed evidence is that the determination was that plaintiff flooded it by putting his clothes in the toilet.
Was there a determination made?
I mean, I guess that would be the inference drawn. I think that's the reasonable inference drawn from the evidence. I don't know if your honor's asking if there was like an independent report made or something.
Here's what I'm trying to ascertain.
Okay.
Was there something that the defendant did that remedied that condition so that if there was a problem, were there repairs made so that flooding shouldn't be, or that it shouldn't be leaking again?
Your honor, I don't think that evidence is in the record on appeal as to what particular, remediations were made or were not made.
Then what we know, I assume, is that there was a report of flooding from the toilet. The toilet had flooded. They inspected it. We don't know whether there were repairs made, but because they inspected it and cleaned it up, that there shouldn't be any more flooding, right?
Correct, your honor.
But we don't know if any repairs were made to correct the condition, or if no repairs were necessary, or what the cause was. So weren't they then on some kind of notice that perhaps they should check it again?
I'm not sure where there's a legal duty from them at that point to do other than what's required by the statute, to go in and, again, if they didn't have any, I'm sorry, go ahead.
Required by statute to do then?
Well, to remove filth from the plaintiff's cell every 24 hours. So, I mean, short of being noticed that there's filth.
See if it was leaking?
Well, I don't think the duty is to, I think the only evidence is that they determined a source of the problem.
What did they? You seem to be equivocating on whether they determined the source or that they just went in.
I think they determined the source. I don't know. I mean, I guess as far as what particular was remediated or done to fix the source, I don't know if they take clothing out or what had to be done. But I mean,
well, what I'm trying to figure out is, did they determine there was no leak, or there was a leak? Did they fix something? What did they do?
I don't know. That is not in the record.
So if they didn't determine what the problem was, or they didn't make repairs, how can you then say that any notice given up to that point of time is not good notice for anything that may happen in the future.
Well, I mean, I guess my response to that is that you can only work, with what is in the record and what is undisputed. I mean,
And
again, if there's no notice of something that's recurring, that's not the circumstances they were presented with. They were not presented with circumstances that something was recurring or likely to happen again.
I thought Mr. Justice said
Isolated.
that the proof indicated that this had happened before,
What is this?
that the toilet had flooded before.
Well,
He
we're
had
not,
reported it before.
but it's not okay, so it's not, that's the distinction. This is not a flooding, right? His complaint was that there was water, and I don't even know the specificity with which he complained because it's not in the record. He essentially says Pam Freeman walked past my cell and I pointed at my toilet. But the water he's complaining of that he fell on this particular day is water sourcing from the base of the toilet. A small leak there that would run out. Whereas what happened on December 18th was a full flooding, overflowing of the toilet. So if that's what the officers were presented with on that day, I don't think that presents them with facts that was, going to reoccur or would give them any other duty than to address the flooding right there. And that's the only evidence in the record that they addressed it, they cleaned it, and then that was it. And moving forward, there's no proof that they had any knowledge that the water did come back until he fell.
And those are the only two instances that are recorded in the record of water on the floor.
Yes, Your Honor.
Okay.
But as we are asking Your Honors to consider the alternative grounds for dismissal in this case. I understand this is a court of appellate jurisdiction. I would respectfully submit that it is in your all's discretion where a case has been fully briefed, argued, and heard, and particularly in a de novo review where you all would be making fresh determinations as to the facts in this case anyways, that there is all the evidence in the record that Your Honors would have to determine that the issue of comparative fault in this matter, which of course we have fully briefed. The plaintiff undisputedly knew and appreciated the dangerous condition in this case. He lived with it for a month. He had previously fallen in the water. He had fallen in it 2 days earlier, and then 2 days later decided to go through the water faster. Apparently did not learn anything from the first instance. And he did have an alternate dry path to go through. There's not proof before this court as to any physical limitation that would have, kept Mr. Vaughn from walking to the other side of his small cell to walk to the door to get to the food. There was no emergency compelled on him at that time. And so the defendants would submit that is certainly still a viable ground for dismissal in this case, should the court please.
So let me ask you, after the fall on the 20th of December, was there any determination made that the seal of that toilet was leaking? And that's why there was water on the floor on the 20th?
I don't believe that there's any proof as to that in the record, Your Honor.
Okay.
All right. Thank you for your argument. We will hear rebuttal from the appellant. You're muted, Mr. Justice.
On this issue of Mr. Vaughn being able to go around the water, Mr. Vaughn testified that this water, due to just the leak, not the overflowed toilet, but the leak, which was continual, that the water made up most of the way toward the exit to his cell, and that the only way he could get around it would be to climb over the bed and then slide along the wall. And due to the fact that this is an older gentleman, we just submit that that's, especially due to the fact this is an older gentleman and a mentally ill person, that's just not a reasonable way to house someone. Especially, it's certainly not a reasonable way to house someone for 30 days or more. In terms of this issue about the overflowing toilet, the whole issue of the overflowing toilet, or this issue of this accusation of Mr. Vaughn causing it on purpose or causing it at all, is entirely based on hearsay. It's just a message from a nurse to Mr. Vaughn saying what an unknown, unnamed guard told her. So it is hearsay, and there's no actual evidence that Mr. Vaughn did anything wrong. We would just submit that the toilet was finicky and he had problems with it that day, and it did wind up overflowing. But and the overflowing really is different from the leak in the sense that the leak was water that basically blocked the exit to Mr. Vaughn's cell, whereas the overflowing added on to that and spread out even under Mr. Vaughn's door and into the public area. And due to the fact the drains apparently didn't work in that part of the jail, it just then sat there and flooded for apparently over a day until they finally wound up cleaning it up. But again, that's really a separate issue from the leaking. The leaking was a continuous problem. The overflowing was just a temporary problem because somehow the toilet got stopped up. And we just submit that the fact they clean up the water once from that secondary problem, that doesn't take away the notice they've had over the prior 30 days or more about the continual problem. From the plaintiff's perspective, this water's been leaking every day for a month. The guards have had a duty to inspect every day for a month. So that's a continuing condition. The defendant has said, well, it wasn't a recurring incident. It didn't have to be a recurring incident. The case law says recurring incident or a continuing condition, and that's what it was. In addition to that, Mr. Vaughn, again, over that time testified that he told 4 different people. In terms of whether we've highlighted his testimony in the case below, anyway, I'm out of time.
Well, Mr. Justice, let me ask a question. So the fall on the 20th, was it because the toilet overflowed, or was it from a leak?
He testified it was from a leak, and it was after the flooding had already been cleaned up, but then it just started leaking again because it was a continual leak. It was a slow leak, so it's not going to leak within a few minutes, but I mean, it doesn't, it's not that slow. It leaked out again by that point.
And is there any proof in the record that after the fall, there was a maintenance inspection and they found that there was a leak around the seal of the toilet?
No, and the problem is we asked for the maintenance records in this case, and the maintenance records, and I think they're part of the record, they're just very sketchy. They don't document any problem in that cell at all at any point. They document lots of problems throughout the course of the year that are never documented as being fixed. So overall, the maintenance records are just have a lot of holes in them.
But I'm asking about the maintenance record for the 20th of December.
There's not a specific maintenance record for either the overflowed toilet or a leak or that cell period, I don't believe. But again, those are in the record if you want to look at them. Thank you all for your time. We ask for reversal and remand of the case.
Thank you for participating in this Zoom oral argument. We will take this matter under advisement and will attempt to render an opinion at the earliest possible time. Ms. Kraft, anything before we recess court for today?
No, sir.
You may recess court.
This Honorable Court of Tennessee stands adjourned.
Thank you.
Thank you.